All right, welcome to the legal issues part of Nuts and Bolts. My name is Joe Hadzima, and tonight we're going to be doing legal issues. But I want to first highlight that this is for background education only, and it's not really legal advice. And there are three reasons for that. One, legal issues are very fact determinate, so applying them to a particular case could be different if the facts are different. The second is the law changes, regulations, court cases, etc. And the third, I don't want any liability. I'm in lawyer mode now. So with that caveat, what I'm going to try to do is walk through a life cycle of a venture from the idea phase all the way through to, fully funded. And I'm going to look at it across a couple of different areas: intellectual property, the legal entity, people, and what's the final one there? Financing. Now, I've done this a number of times, and what I've learned is I'm never going to get through it all. So on the website and on this deck that I'll be posting later, there are videos for the segments that I may not get to. So rather than race through things and leave you wondering in the dust about a lot of stuff, I'm going to take it at a hopefully good pace with understanding we may run out of time, or we will run out of time. Okay? Good. So at the idea stage and pre-financing, if we look at intellectual property, there are two sort of areas. The first one is who owns the idea? And then the second is, can we protect it? So who owns it, and can we protect it? Now, why does that matter? In 2020, actually I updated this from, what was the first one there, 2015. See how far the bar went up? This is, if you take the market capitalization of the Fortune or the S&P 500, and market cap is the share price times the number of shares, gives you the market value. And you look at the balance sheet of the company, and you look and you say, what on the balance sheet are tangible assets, like plant, equipment, real estate? And you subtract that from the market cap, the rest are intangibles. And so it's 90% for the S&P 500 are intangibles. Now that includes intellectual capital, which are your people, your know-how, sort of your team, and other things related to that. And it can be brand and other sorts of things. But when we come to intellectual property, and by that I mean things that can be legally protected, that's somewhere between 30 and 40% of that value. Now, obviously that depends on the sector you're in. For pharmaceuticals, once a drug goes off patent, if there's not another one coming along, you can see the stock price drops quite a bit. So for that kind of industry, it's very important. For others, it's maybe not as important. The main point is increasingly intangibles and intellectual assets are what create value. So let's look at those. Oops. Have a small timeout here. All right. Oh, okay. So you didn't hear anything else I said before. So you will be responsible for it, though, in the final exam. Okay, so when we talk about IP, what kind of IP is out there? How do we categorize it? If you're trying to protect it, well, first, you may not be able to protect it at all. That means there's no way to protect it. And then we have trade secrets. And those are things that are obviously secret that other people don't know about. And you have trademark, service mark. We'll talk a little bit about what that is. Copyright and patent. And some things you want to protect may be multiple, like software can be covered both through patents and copyright. So if we look at what do they do? Well, trade secrets can prevent others, right? Because if they don't know your secret, they can't do it. So that's good protection. Trademarks and copyrights can enhance value, but they don't actually block people from doing similar things. And we'll define what a trademark is and how copyright works on that. Patents actually cut both ways, because as I'll explain more a little bit later, it's a societal bargain. We don't like monopolies. We have antitrust laws. But a patent is a limited time monopoly. It's mentioned in the Constitution, in a sense. And the question is, well, why do we allow that? Well, because we give a limited time monopoly to the inventor in exchange for describing what the invention is. So you're actually disclosing what you're doing, and you're given a limited time. So it cuts both ways. If you kept it totally secret, nobody could do it. But probably, for most things you're going to do, people are going to figure it out. We'll come back to exceptions. Now, from a duration viewpoint, a trade secret is a secret as long as you keep it. I understand the formula for Coca-Cola is still secret after 100+ years. Don't understand exactly how that works. Trademark and copyright have can have some durations to them, and patents are the shortest in the sense that, I'm sorry, here we go, cost. We go to cost. It goes opposite, right? So now let me go back to duration, sorry. And patents are about 20 years in terms of duration from the date of filing of the patent. From a cost viewpoint, it's almost the other way, potentially. I mean, people spend money protecting trade secrets, but if you keep it locked up in a vault somewhere, it may not cost anything. Patents, on the other hand, can be very expensive. As you'll see, I'll give you some numbers on that. So that's sort of the menu that we're looking at for protecting ideas. Are we good? Okay, all right. And this is all country by country. Each country has their own patent and intellectual property systems. There are some international things that try to coordinate those. I'm going to focus just on the US, which is a pretty good metric for most of the rest of the world. All right, so a trade secret is a secret. Gives you an advantage over other people. Formula for Coca-Cola is a classic. The protection varies from state to state. And as long as it's a secret, you're protected. So it's often, people try to get non-disclosure agreements. I'm going to tell you something, and you can only use it for this purpose, etc. Now, when you go to financing sources, particularly venture capital firms, most of them will not sign a non-disclosure agreement. And the reason is, as we said the other night, most inventions or innovations are not revolutionary, they're evolutionary. And so if you're thinking about something, someone else is probably, and they don't want to be bound by you, with you on a non-disclosure if the next person comes in. Yeah?
When a couple of slides back, when we saw the increase on the graph, is that because the market is recognizing more intellectual property from a valuation standpoint, or is there more investment in R&D that's creating that increase in valuation?
Okay, so the question for those on the streaming is, what's accounting for the increase in the percentage intangibles? It could be anything. It could be more R&D, although R&D is generally going down in the US as a percentage of revenue for companies. And we know there's been cutbacks at the federal level. It can be innovation. It can be creative ways of doing things. You have a way of, we had Rich Kivo last night talking about business models and things that never existed before. Amazon is a really big thing compared to just a bunch of independent bookstores 20, 30 years ago. So it's a whole variety of things. It could be the market's just crazy. That's another discussion. Okay, for your venture pitch or deck or whatever, Don't put the trade secrets in. It's sort of obvious. If it's going to be secret, don't put it in there. When Bob comes in and talks about pitching, what you're really trying to do is convey what your value is, and underneath it all is how you do it. But if you start off saying, here's how I do it, without telling you, what value is created, you got it sort of backwards. If your audience believes there's something there, then you can go deeper, but not up front. Okay, trademark and service marks. A trademark is, creating a name for yourself, I call it. It can be, and actually words, it could be a logo, color, the bottom of these shoes, our trademark. If you come up with a pair of women's shoes like that and you paint them red, you'll get sued for infringing that trademark. It can also be sound. Does anyone know what a Harley motorcycle sounds like? I think that one's actually trademarked. So if you have a little scooter and you make a sound like a Harley, you may be in trouble. Trademark is for goods, and service mark is for services. Now you can think of it as a couple level. I call it a house mark. So Lenovo is a company, but it's also a brand. And MGM is a company. And if you see the old films with the lion's roar, that roar is actually, I think, trademarked. Okay, but those houses, those brands sell things like Lenovo sells ThinkPads. That's a computer, and that's a separate trademark. And the movie Rocky, is a product mark for that movie. Now, the rights to a trademark come from using it in commerce. As soon as you use it in commerce, you have a right to claim a trademark. If you don't register with the federal government, you can put a TM for a trademark or an SM saying, I'm claiming this as a service mark. If you register with the federal government at the US Patent and Trademark Office, excuse me, and they issue you a registered trademark, you can put the R in the circle. And what that does, excuse me, is it gives you rights over anybody else using it anywhere, except for people that are senior unregistered users. Think about that for a second while I do this. What is a senior unregistered user? When McDonald's, the Golden Arch people, went to register McDonald's as a trademark, it turned out there was a 2 or 3 restaurant chain in upstate New York called McDonald's. But McDonald's, the Double Arch people, got the trademark, but they couldn't prevent the pre-existing use from continuing. They just can't expand beyond that area. Okay? Now, it used to be 20 years ago or so, you'd have to actually use it in commerce. You'd have to ship a product or provide a service. And the problem with that is you'd have to take a while to get the product there, and you're going to develop all the marketing materials only to find out you can't get a mark or somebody else has it. So today you can file what's called an intent to use. I'm going to use this mark for these goods or services. And then you have, I think, 3 years, or I have to check that. You have a period of time in which you actually then have to use it. But it allows you to, not go out and test things and do things before you actually commit. And you register by a class of goods or services. So you can have actually the same mark in different classes from different people. That's not a great thing from a business viewpoint because of confusion, but and you want to pick a fanciful mark if you're going to pick something, like Apple. I mean, who would ever think an Apple was a computer or an iPhone, or that an iPod was a musical device? If you pick something that's merely descriptive, you'll have a harder time to get it. You might not even be able to get it. So storage technology, what do you think they do? What are analog devices? What do they make? Right? I went in for a trademark for microdose, for low dosage aspirin. This is when I was young in my career. I got slapped down pretty quickly. It's merely descriptive of what I'm selling, so you can't get that. Come up with something else. And you can check it. Go to the USPTO. There's a search base, at least federally. Now, if you're really serious about it, there are companies that will go and search. They'll do internet searches. They'll look at registrations at the state level, if you want a full clearance. And those probably cost a couple $1,000. But you can do a quick one at the USPTO. Okay? All right, copyright. Gosh, it's the right to make and prevent copying. It arises as soon as you create something. So if I write a letter to my mother, I have a copyright in that letter by the mere writing of it. Okay. It protects the expression of what's being protected, not the function, right? And why is that? So let's say we had a different rule, and I'm the first author to come up with the idea that wouldn't it be very interesting to write about a love triangle? All the intrigue, all of the, that's some of the greatest literature out there. But if I had the right to prevent anyone else from writing about that topic, then there wouldn't be any literature. What it is somebody can't copy the way I do it. So it copies the expression, not the idea. Federal registration is a plus. You need it in order to sue if you want to sue for infringement. The duration, if you register it, is 70 plus years, and the cost is pretty low. You file with the Library of Congress, and there's a whole set of issues if you're trying to copyright source code, because obviously if you put the whole code out there, everyone sees what you're doing. So there's a whole procedure for redacting parts of it, etc. Now, you should notify people that you're claiming a copyright. And until you actually register it, don't use the C in the circle. As you see at the bottom of the slides, I just have copyright. If you look at the slides, there's something in it that says, you granted permission to use with attribution for education purposes. That's sort of my implicit license. Let me just finish. And all rights reserved. In some other countries, that's important to put there, so I just put it there. Question?
Yeah. I was going to ask, you say that it arises from creating work. If you created the slide and did not put the copyright on the bottom,
I still have a copyright.
You still have the copyright.
But I haven't given you notice. So, you can innocently not know that I'm claiming the copyright. You might have found it on the internet somewhere. So I'm giving you notice that, hey, that's my slide. Right, if you want to, it's like anything, if you have sort of legal rights, you sort of have to do things to secure them. So, was there another? Yeah.
So just by writing copyright, it helps you, whether or not you did anything like else, just by literally writing copyright on the slides.
Right,
or on
it's just saying, hey, I wrote this is mine. No, but if I want to come after you and sue you for using my slide, I have to go register the copyright before I can bring suit in federal court. Yeah, but then the question is, well, why did you wait so long? I mean, if it's yeah, so look, in my case, I don't care if people copy this. I mean, I'm doing this course because I want you all to learn stuff, right? So I just want, some attribution, at the end of the day, hey, I did this. But if I was serious, and I was really trying to do something where I was claiming Mickey Mouse or something like that, I'd be a lot more diligent about registering that sort of thing.
one state and have an international.
Copyright is a federal in the U.S., and trademark is state by state and federal. Okay, and there are copyright treaties. For your venture, this is important. Make sure you have the rights you need. The ownership of something that's copyrighted, that's copyright, is in the author, right? So if I am starting a company and you come on board as a part-time unpaid consultant, you're the author, and you own the copyright. If I employ you, actually, I own the copyright because of the employment relationship, right? So when you hire a consultant, you want to do something that's called a work for hire. You state this is being done as a work for hire, and that the ownership will be with me, because I'm hiring you. I once had, back in my days, law practice days, a company that did import-export had paid an independent contractor, consulting firm, whatever, about $500,000 to write a complete system for online system for tracking imports and exports and filing the paperwork and all that. And they came to me and they said, you know, our competitors are using the system. The guys who wrote it for us are licensing them. You got to stop them. And I said, let me see the contract that you wrote when you spent the $500,000. It did not have anything about work for hire. And I said, well, you just spent $500,000 for a system that anybody could have. So next time, you know, check with me before you do that. So for you, be careful. Now the flip side is a lot of people start off in service businesses. You know, one way to do a venture is you provide services to people, right? You're a consultant, and then you learn from the people you're consulting to, and you learn about what their needs are, and then you maybe can go into a product company. So when you go to work as an independent contractor for a large company, they're going to hand you their standard consultant agreement. And in there, it's going to say, guess what? Everything you do is owned by the big company, right? And you're going to go, oops. And one of the companies I'll tell you about later that I co-founded, we would have this all the time with big companies. So what I did is I wrote a little memo explaining, okay, here's how it works. You're going to ask us to do something. We're going to go look at our data. We're going to use our analytics, and we're going to produce a report. You can own that report. If the next person comes along and asks me the same question, they're probably going to get the same report unless the data has changed. So I can't have you own all of what I'm doing. You can own what my output. So, and usually that I'd ship that up to the legal department, because you deal with somebody who says, geez, I don't want to take it up to the legal department. It's going to take forever. And just show them this memo, and here's some suggested language you can, as an addendum. And we'd usually get that done pretty quickly. But for you, this idea of who owns it.
Helpful words. Do you have a sample of that?
Yeah, I probably could dig it up. Yeah, okay. Well, it's very specific to what we were doing.
Owning it, I think a lot of people might.
Well, it's the same thing if you're a software, you're writing code for somebody, right? There are algorithms or code snippets that you develop that you pull together. I'm going to take this thing and I'm going to do that, and I'm going to use this, right? And those things you came pre-existing. So you could say, I get to own those. You don't get to own those just because I used them. You get to own the thing I wrote, but I still retain rights. And then the question is, you know, if it's a big major thing you're doing and you really want to own something you develop for that, then you got to work that out. But the important thing is, if you don't think about that and someone comes along and you've got a venture and they want to do some due diligence on you and find out, you know, you don't actually own that code. Oops. I think I'll go look at another company to invest in. And I put down here, check the open source issue. So, you know, if you're using open source, make sure you look at the license to make sure that you're using it correctly. You know, you're not modifying the open source code, because under that, you're supposed to give it back. I'm using this MySQL to access my database. You know, I can do that because of the MySQL license. Okay. Now the whole thing, because I know it's going to come up, copyright and AI. It's definitely been always the case that human beings are the ones that are entitled to copyright, not machines. But the Copyright Office has come up with something that says, look, you can use artificial intelligence as long as you're doing the creative part, putting it together. You're rearranging things, you know, just like you might pull together different pieces. And it's a continuing thing. And there's a address you can go check and see the latest on that. The other thing is copyright and the AI, the training of models. The law is unsettled. It'll probably continue for a while. The concept is fair use. Under the copyright law, somebody's entitled to fair use of your copyrighted material. It's very specific. It looks at 4 factors. What's the purpose of use? Is it to comment on someone's poem or to write a newspaper article? Or is it to go out and, what's the purpose of the use? What's the nature of the work? Is it you're going to put a commercial product out there or not? The amount used, if I take a snippet, I quoted last night something from Thomas Edison. That's fair use because I didn't take everything he did. This came up, for example, a lot of the very specialized newsletters that you pay thousands of dollars subscriptions for. Law firms at one point would copy them and send them around just so they wouldn't lose them. And they got dinged for that, saying, wait, that's taking our whole thing. You can't do that. And the market effect, that's just basically what I was explaining. So those are the 4 factors. Now, the other aspect of AI and copyright is, okay, maybe I can use AI to train my models, but the models are going to output something. And if the response comes back is basically taking a big chunk of something I've written as the output, that's a different thing. If the AI is saying, well, Joe Hadzima says this about that and paraphrases what I'm doing, as opposed to, here's a slide Joe did, that would be a different issue. So anyway, evolving area, if any of you are doing things in AI and are worried about it, I'll give you some things to look at there. Okay, yeah.
Work for hire. So if they says I am work for hire, like they're hiring me, does that mean that they own everything, or the other way around?
No, it's if the person who hires you says I'm hiring you as a work for hire. Usually you put it in a writing agreement, written agreement. Then I would own it because I'm hiring you to write the work. Now, given that obviously people put language around that, but right. Right. But if I don't say anything, it's like that input-output or the import-export software. They paid $500,000 for it, and they didn't actually own it. They obviously had the right to use what was produced because that's what they contracted for, but they don't own the thing. So think of it as a license. Okay, patents. This is, again, a limited time monopoly. I explained that a little bit earlier. It's granted at the federal level or the country level for anything that's new, non-obvious, and useful. Now, you have to think about it. It's very much like real estate. If I own a piece of property, I have the right to keep you from trespassing on that property, right? That doesn't mean that I can actually use my property. Why would that be? In what case would I not be able to use my own property? Anybody? What if I had to walk across your land to get to my property? You could prevent me from trespassing on your land, right? And maybe my land is, I'm landlocked around you. Well, maybe. It's the right to prevent others from doing something. It's not the right to use it yourself. I'll show you a slide on that. It's from making, using, selling, or importing whatever the patented invention is. And that's the real estate. Now, the claims on the patent are like the fence that define what the property is. So that's what claims are for. 20 years from filing. All right, so this highlights the point. Let's say nobody ever thought of the idea of a vessel to hold a liquid. Nobody ever thought of it. I came up with that great idea, and I patented it. So, right? You, on the other hand, come up with the idea, handles are useful for things. Nobody ever thought of handles. Okay? You own the handle patent, I own the cup patent, or the vessel to hold a liquid. There can't be a handle on my vessel unless there's a cross license, because you can prevent me from putting your handle on my vessel, and I can prevent you from putting my vessel on your handle. Okay, we'll come back to that a little more. That's really the right to prevent others. Okay, so the requirements, it has to be something new. You have to cite prior art, as it's called, prior things out there that are relevant to determining whether what you're proposing to patent is new or novel. And I'm going to show you how I've used that to do some things. Because if you fail to cite the prior art in the course of examination, and it later comes out that you failed, you knew it, but you didn't cite it, it can be grounds for kicking the whole patent out, even if it otherwise was perfectly valid patent, because it's fraud on the patent office. So let's say I forgot. I purposely didn't tell the patent office that you had some prior art. Had I told the patent office, I might still have gotten my patent, because they would have said, well, you're actually, that prior art doesn't affect your patent, or you might have to change your claims or something. But the fact that I didn't tell now could invalidate my whole patent in litigation. So, it's things you don't know. And that comes back. Does somebody ask me last night about doing a patent search? Where? Okay, I can't see with the light. And what I said is when we were doing work for companies trying to figure intellectual property strategy, the lawyers in the company would say, oh, you don't want to do searches. Excuse me? No, don't do searches. If you find something, you have to disclose it to the patent office. I said, oh, that's true. That's what the law says. I said, okay, so what I want you to do is, would you come with me to the Grand Canyon? Okay. I'm going to put a blindfold on you, and I'm going to spin you around 10 times. You can walk in any direction you want. Would you do that? Oh, no. Why? I might fall off the cliff. Well, if you're telling people don't figure out what's there, they're going to invest all this time and money and stuff only to find out later on they've essentially fallen off a cliff. So while you're perfectly accurate, Mr. Lawyer, saying this is what the law says, you have to disclose it, it's stupid from a business standpoint as a general proposition. Now, there's exceptions to anything, but it used to drive me nuts. The business people would go, yeah, of course. Makes perfect sense. The thing you're claiming has to be useful. That's usually not a problem, although there are some pretty weird patents out there. I think propeller on beanies and things like that. It has to be patentable subject matter. Process, machine, manufacturer, or composition of matter, and a lot of the computer software patents. There's a whole set of tests now as to whether, they're truly patentable, but we won't go into that tonight. It can't have been previously offered or publicly described. Now, in the US, you have 1 year from the date you make an enabling disclosure, or you offer something. So if you're going into trying to do a license agreement with somebody, and you're sort of offering the technology, even under a non-disclosure agreement, that could still trip you up. The enabling disclosure part, though, is if I say to you, I have invented anti-gravity boots. I haven't told you how I've done it, so it's not enabling. But you have to be a little bit careful. The 1 year thing means in the US, if I do make a disclosure, if I, let's say tonight I describe some invention that I have a year in the US to go file an application at the patent office. If I wait more than a year, I won't be able to file, I won't be able to get a patent. The rest of the world is basically different. There, you have to file before you disclose. So I was in Istanbul a number of years ago at one of this global entrepreneurship things, and we were coaching some teams, and one team, I think it was from Egypt, came up and they were really excited. They had this new thing with way to increase the bandwidth on wireless networks and this and that, and it really was revolutionary. And I said, gee, that sounds fantastic. Have you published anything? Oh, yes, our paper's in this prestigious journal. And I went, oops, you may not be able to get a patent any place except the US, depending on what that paper says. So you should have seen them just sort of slump in the chair on that. So I want you to be aware of this so you don't do something like that. The invention has to be not obvious. So in other words, we're not giving inventions on little tweaky improvements on things that anyone else could figure out who was of ordinary skill in the art. Now there are ways around that. If the prior art teaches that you can't do it this way, and yet you've done it, or all of a sudden people are buying it and nobody else did. Other ways to show that it's not obvious. And in the US now, it used to be that the first to invent got the patent over somebody who was the second to invent. Now it's the first inventor to file. And that's a big change. Especially when you come into things like if you're doing joint ventures and you've got when you have two companies coming together to invent things, the real question is, well, whose idea was it? And when you do those collaboration agreements, it gets kind of tricky to figure that out. Okay, so those are sort of the basics. Now let's think about it from a new venture viewpoint. You want to be able to assure yourself and your investors that you have the freedom to make, license, and sell the product or service you're thinking about, right? You don't want to be hung up on that. So the first thing is, do you actually own the invention? The same kind of thing we talked about with, copyright. Was it assigned by the inventor to the company? Now, when you go to work as a technical employee at a company, there's usually a patent disclosure, invention, and assignment agreement that you have to sign, sort of a standard type of thing. Maybe it was licensed from the university, or maybe not. There are people that have tried to take ideas out of universities that they should have licensed and try to end run that, and they've tripped up when investors figure that out and said, we're not. First of all, the fact that you would try to do that suggests maybe you're not the most ethical person, and maybe I don't want to invest in you. Or at least it says you don't really understand what's going on. And I'll talk a little bit about licensing from universities. And did it go into the public domain? Did you inadvertently or disclose it and make it something you can't protect? And then the question from a viewpoint of a venture is, what's your strategy? Are you going to patent? Or maybe you want to disclose to prevent others from patenting. I'll come back and talk about that disclosure to prevent others. Now, that's one side. Do you own and can you get a patent and protect your stuff? The other side is somebody else going to prevent you from doing something. Are there people out there with rights that are going to prevent it? Can you get a license? These are important things for you to grow the business, and certainly investors are going to be interested in that. There is the concept of willful infringement in the statute. If you willfully infringe a patent, and it's shown that you've done that, it can be 3 times the damages, and it can be a real mess. And the defense to that is an opinion of counsel saying, I've looked at the prior art and what they're proposing to do, and my opinion is this is not an infringement. That's expensive. Whoever talked to last night, that would be one reason if it's very important to get one of those opinions. Not for every case, but think about it. And failure to figure this out before you launch could be a real problem. Okay, so how do you figure out what's out there? This is a company that I co-founded. and it's still out there. It's called, the website that's publicly available is called c-the-forest.com. And the reason is we were looking at commercializing early stage technologies out of basically MIT, and people would come and say, you know, I've got this idea, and we'd say, well, gee, I wonder what the prior art looks like. And actually, there's a company that I co-founded, and we went out and spent a bunch of money with an outside firm to do a massive prior art search, because what we were going to do would be big in the energy space, and we were going to be playing with, you know, the biggest companies on the planet. We wanted to make sure we were clear. It took forever. It took like 8 or 9 months and cost close to $100,000. This was probably 20 years ago. Real money. And it has to be a better way. So we started to think about it and said, well, what if we could visualize the intellectual property space? So this is an example of our patent maps. In this case, the yellow shaded patent is a Tesla patent. The way this works is all those boxes are patents. They're aligned in time. The lines between the boxes are the prior art citations. So this Tesla patent cited all these other patents as prior art. And you can see that when you look at the patent. And you display them in time, and you can see who they are. The tails on the boxes show when they were filed. This map tells you who's on who was there. So that was when that patent issued. In 2010, that's what it looks like today. All these, that big fan to the right, those are all the patents that have issued in the last 15 years that cite this Tesla patent. And the question is, who are them? Who are these people? Why are they citing? You know, you don't have to read all these patents to sort of figure out what's going on here. You can look at this at a fairly high level, and then you can click and look at the actual patents. And so using something like this, you can pretty quickly see what's in the space. That's called a landscape map of a single patent. Here's a patent, show me who it cites and who cites it. This is called an interconnection map, where I have a group of patents and I want to see what their relationship is. This is the Tesla portfolio in 2018. You can see at the top there are a bunch that sort of cross-cite each other. That's sort of a whole product suite going there. The ones towards the bottom tend to be new things that haven't yet cited anything in the portfolio. This is what it looks like when I ran it last week. They've developed all those patents since 2010. And so by looking at this, you can begin to understand, you know, what are they doing? What are they patenting? You know, what do I need to be aware? Are some of these people, if I go back to this one, you know, are these people potential customers? Are they potential collaborators, competitors, possibly acquirers? Maybe I'm building something. We did some exercise with the SBIR program at NSF, where people were trying to in phase 2, trying to figure out where should we commercialize. And by patenting, looking at the patent space, it helped guide their commercialization strategy. So anyway, if you are interested, go to the website. You can register for free. If you're MIT, send me an email saying, I took the class and we'll give you an upgrade for free, so you can use a little bit more of it if you want. Not required for the course, but may be useful. Okay, yep. Any other questions? Yeah.
So in Tesla's case, if they see that graph, and let's say general counsel of Tesla, are they then thinking about, are these people that we may need to defend our IP against?
Or maybe, I don't know. Who are these people, right? There's a special case for Tesla. I'm going to show you it a little bit. But the question would be, what are these people doing? Are they building off our technology? Are they infringing? Maybe, possibly. But they're in our space. We should know about them. They might be somebody we might want to acquire or partner with. You know, I've got a core technology, but they're doing it in this industry, or they're doing it there. So it takes it from a higher level, like, here's here, Mr. Executive or Miss Executive, here are 200 patents. Why don't you read those tonight and figure out what your strategy is? Most executives are going to say, you're out of your mind. I'm not going to read. Have you ever read a patent? If you can't sleep, it's a great way to go to sleep. These things can be deadly, right? But this, on the other hand, we had a, I can say it at this point. So at one point we went out to EMC. People remember EMC? I know some people in the audience do, yeah. And we were there with Dick Egan, one of the founders, and back then we had the big plots. They weren't online. You couldn't click through, and we laid it out. And at the top the way the algorithm works. At the top are the things that are most clustered. It minimizes the number of cross lines. And so Dick looks at it and says, "Yeah, that's our stuff. That's the stuff I'm talking to Wall Street about. Yeah, right there. And down here, I don't know. That must be like cabinets or something." And his patent counsel's there. He had his magnifying glass out because it was only like a 3x6 plot, and he sort of blurts out, "Actually, this one down here is the one you've been talking to Wall Street about." And Dick looks and says, "It's not citing anything else in our portfolio. What's all this?" He used a couple of expletives. If you know Dick, you know what he probably said. What's going on here? I'm telling Wall Street our future is here, and this is the only patent we have. What is all this? It was like, guys, let's figure out what the business is here. It was quite interesting, kind of embarrassing, but quite interesting. Okay, obtaining a patent. Determining what to patent, when, and preparing, and then prosecuting. So let's talk about it. What to patent? From a lot of technologists want to patent everything they do because, hey, it's a good invention. In fact, some companies, you heard last night, they pay for people to file what are called disclosures with the company. Here's an idea I have, and then they have a patent committee to decide whether is this something that we should patent or whatever. The question is, what do you want to patent? What's of value to your company? Could the competitors engineer around it if we patented it as opposed to maybe keeping it a secret? And could I detect infringers anyway? If you have a process, how do you tell if somebody infringed a process? Now, here's a golf ball. Here's another golf ball. I made mine with my patented process. How did you make yours? Trying to enforce it, can be a problem. So you might not want to think about processes. And you want to look at prior art to see how it fits in. When to file, we already talked about it, before you lose US or foreign rights. The first inventor to file wins. And this one is sort of interesting. In time to have a patent to protect your product or service. So a few years ago, pre-COVID, because COVID screwed this up, we were in the midst of a collaboration negotiation with a big consumer products company. And we had plenty of patent applications. And we looked, hey, look at all these patent applications we have. We're protecting it and everything. There were about 3 pages of this long document about what would happen if the patent didn't issue. And the way it was written was kind of stupid. It said, if none of the patents issues with a claim, well, you can get a patent issued with any claim if you make it so small. I claim this bit of sidewalk only in the summer between the hours of 1 and 2 if the sun's shining. That would have probably worked under the way they drafted it. So anyway, we're thinking, what are we going to do here? And then I got notice that our applications had been approved in the US and China and Europe that week. So I came back and I said, hey, look, we now have 3 patents. Whole section of the agreement peeled away, and all of a sudden they were talking about a higher royalty because now they knew we had something. I said, now that we have it, we're going to talk about royalties. So it was good timing because we had planned ahead of time. Provisional. Remember I said if you disclose before you file the rest of the world, you're sort of dead? They put in place in the US provisional patent applications. These count as filings for basically every country in the world. And there's something that really, they're called provisional, and then within a year you have to file the actual called utility patent. We have a 1-year stuff. The important thing is it has to have some meaningful description of what the invention is, but you don't have to have claims. The thing that's costly dealing with patent lawyers, you want to pay them. They're expert at writing claims. You know, if you come in, I'll talk a little bit about how to deal with lawyers, other than what did Shakespeare say? First of all, we kill all the lawyers. I think that was. But if you come in and you just drop a lab notebook on a patent lawyer's desk, it's going to, they're charging by the hour. It's going to, you know, you want them to focus on the claims. So there's some work I'm going to show you should do ahead of time. But a provisional, you just have to, I've seen people take a paper that they're going to give at a conference, slap a cover page on it, file it as a provisional. And it protects it. They're cheap, $130, I think, for small, and $64. Nothing happens. It just gets filed. But if you failed, let's say I filed something that said, I've just discovered that fruit and vegetables are great for human health. And let's say nobody else had ever figured that out, and I file a provisional. And then in the course of the year, I discover, you know, protein's important too. And I go to file a utility. If I don't mention protein or steak or something in my provisional, I can't get the priority date. I'll have to file another one. We used provisional patents a lot when we were developing the IP vision system. Every release cycle, we'd sit down and say, what did we do that we think is valuable? And should we file something? What did we think about or learn during that, and should we file something? And we'd file provisionals, and we just had them stringing along, and eventually we'd have to decide whether we're going to, you know, actually turn them into utility patents. Now, again, the same consumer products company, we were trying to do this collaboration between a small company and a huge company. And we said, you know, how do you guys work on provisionals? We don't file provisionals, said the big company. Why don't you do that? Well, we wait until we see whether we want to take a product to market and this, that, and the other thing. And I said, you know, in Silicon Valley, they file provisionals all the time. And if you wait until you're ready to go to market with something, you're going to find a bunch of people have already patented. You can't assume you're the only smart people out there. So, but, you know, their bureaucracy couldn't deal with provisional applications. I don't know, it wasn't in their system or something. It's just like one of the more things you have to deal with when you're dealing with a large company. Okay, quickly, what's a patent look like? It's like a term paper. You've got the field of invention described, you have the background. You should be writing these things before you go talk to a patent lawyer if you're thinking about actually getting a patent. You know, describe the prior art. You know it better, although, you know, most patent lawyers specialize in one area, and they know a lot. They know a lot of things that you might not even know about in those areas. But, you know, what's the prior art? What's out there? Why is yours better? What's broke that you fix? And then you summarize the invention, and then a description of what it is you're actually doing. And there's this concept called best mode. You have to describe the best mode in which you've determined you should practice that invention. And that's the key part of that bargain, remember? We're going to give you a limited time monopoly if you describe what you're doing. So if you sort of hide the best mode and it comes out in litigation later on, that's an important part of it. And the claims, what exactly is the invention? So everything except the claims you can do yourself. It doesn't cost you anything other than time. And as a startup, you're balancing your time versus money you don't have. You know, pay the lawyer to write the claims. Don't try to be a claims person yourself. It's a very arcane set of structures. Costs in the US, filing fees, $5,000 to $15,000 on preparing an application. I should know better, but one month I got a bill from one of our patent firms, And the bill was $35,000 for that month on a single patent application. I said, what is going on here? Why 35,000? Turned out my co-founder, who was a very technical person, was going back and forth with the lawyer. Oh, can we do this? Can we change that? And the lawyer's just ringing up the time. So I had to put my foot down and said, any discussion with the patent lawyers comes through me. We're going to have a discussion first about what we're doing. Then we'll feed it to them. Because 35,000. So anyway, you can control some of that cost. Filing fees, the cost to put it in there are pretty low. There are search and examination fees, and then I didn't put down here the prosecution. Prosecution is the process you go through. It's not like a criminal prosecution or anything. It's the process of going back and forth with the patent office to define, can I get this patent? What do the claims look like? You don't have any real control over how long that takes, unless you're willing to sort of take the first thing the patent office says. So it's hard to guess what that can be. And then there are going to be issue fees that I didn't put on there. Foreign fees start to get expensive when you go international. There are ways of filing in the US and delaying the filing internationally. And national fees, the whole thing gets expensive. There was a case study done by the General Accounting Office probably about 20 years ago now, about 20, that said if you took a patent, an invention, and you wanted to file it in the 10 major industrial countries, file and maintenance and renewal fees, it cost anywhere from $350,000 to $500,000 over the life of the patent. And the reason the range, it depends on the nature of, some countries charge you more for certain types of patents than others, but it's expensive. So the trick from a venture viewpoint, like we did, is you want to file to protect. Provisionals are a great way to do that. And then you hope to either partner up with somebody who's then going to take it and pay the ongoing fees going forward. So remember I said you could disclose as a strategy. If you can't afford to pay all this, what about disclosure? Well, you want to disclose to avoid what's called a picket fence. Remember, the patent is a right to exclude others. So let's say I invented my vessel to hold a liquid, and that's the only patent I get. And other people come along, someone says, gee, I could put a cap on it. How about a sleeve? Maybe a handle. Oh, maybe it should be like insulated or something. They've basically, you might come and picket fence my patent by patenting every other thing that makes it a really commercially viable product. Ooh, that's not good. How do I avoid that? Well, I might not have the money to patent the cap, the sleeve, the handle, the thing, but I can certainly describe them as useful extensions of what my invention is. And once I've done that, nobody else can patent it because I've already disclosed it. So and I don't do this lightly, if you think you can get a very strong patent on the core invention, and that's a discussion you and your patent lawyers should have, then a strategy is make sure we can prevent others from trying to hem us in. Yeah?
The way you word it, do these extensions need to be something that you describe how to implement? If you've not yet added the handle, added the sleeve, added the...
You could describe you could extend this invention by having a handle or some way to carry it. People might come along and try to patent a process for making a handle. There are other things they could do, but to knock off the easy things that could be extensions. Because if you hold the core and nobody else can patent the other stuff, then you can do all these things. But again, you have to understand what the landscape looks like. Yeah.
Does that mean that when you say the person who gets the patent is the first to file?
The first to invent. The first inventor to file, sorry, yes.
Right? But if someone discloses before any of the, or if one of the inventors discloses before either files, then neither can file. Is that correct?
Yeah, well, in the US, you could have that 1 year window for you. But if somebody else has disclosed it, that's a prior art. Yeah. Well, if you do it, you have a 1-year window you can do it. By the way, I've never taken a patent law course. I'm not a patent lawyer. I just have spent a lot of time dealing with patents from a business viewpoint. So again, what I said at the beginning, background, not legal advice. Here's an example of a picket fence. That little patent on the left, that was the main initial application for the Ring doorbell camera. And you can't tell really, but all the other ones are red colored patents. That's Sky Bell. All those patents cite that initial one. And if you read them, those are parts of a potential picket fence. Now, Amazon did buy Ring. I don't know what diligence they did on that. I wrote a blog on that. They must have done something. But that's an example of something that's a picket fence potential. Yeah.
Strategy like Sky Bell was trying to control.
I don't know what the strategy was. So the question with these visualizations are, what's going on here? Why are there, 30 Sky Bell patents citing this patent? Why is that? What's going on? Is it a strategy? Remember, if you fail to disclose something, then it's to the patent office, it's basis for kicking it. So there's a reason they're citing. And now you can have a higher level discussion. So something to think about. Now, Tesla. Before Elon Musk got a little crazy in Washington recently, back when he was just Elon Musk, Tesla, innovative to the world, EV and everything, and they got a lot of patents. You saw all the patents I showed you there. They came out in 2014 and said, we're good guys. We got all these patents. We'll make them available to you. They had a licensing program, and they didn't charge. I don't know, maybe they charged a little bit, but it was basically, come, open source. It's wonderful. Are they good guys? Why would they do that? The answer is a little bit there. What does Tesla make? Or back in the day, electric vehicles. What do you need in order to have a whole market full of electric vehicles? You need infrastructure, you need chargers, you may need batteries, you may need stuff. And if they can get patents on all that stuff and control it to prevent people from blocking them, then they're very happy to say, you want to make chargers? I love it. More chargers, the more cars I sell. Henry Ford, when he made the automobile, he didn't have to go and find oil and drill it and refine it and distribute it. He didn't have to, pave roads and stuff. So, there are situations in which you want to enable an infrastructure, an ecosystem around your technology in order to advance your business proposition. Now, for nonprofits, you'd say, well, no nonprofits should never get, why would they get patents? Well, again, if you have technology and you're trying to take a product to another country and you find knockoffs or other things that are inhibiting your ability for your mission, that might be a strategy, something to think about. Most of the time, patent strategy used to be patent what you invent and make sure you don't infringe. But if I make pencils and my competitor makes pencils and cups, I might want to file some cup patents. So I have something to protect my revenue streams, possibly license or other things. So thinking strategically about your business and what you're trying to protect, which is your revenue streams and your profitability, or your mission, if it's a nonprofit, is a different way of thinking about it. Okay, so goal-oriented, what's your core technology? Do you have a product? Is it short-lived? Is things changing rapidly so you'll be obsolete? From your business model, are you going to make and sell it, or are you going to license it? If you're going to license it, it helps to have some patent. What are you going to license? If you don't have some patents, you have some technology. That'll evolve the strategy that you have. And there may be non-IP bars to entry, like regulatory or other economic. And then possibly for an exit strategy, you should think about IP as part of a bigger picture. So just don't rush in and patent everything. Think strategically about, what's your business model, your plan, where you're going, what do you see down the road. Practical advice for employees: make sure you have invention, disclosure, and assignment agreements. With consultants, make sure you have covered the work for hire. Use NDAs where appropriate. Avoid infringement. Keep an eye on what's going on, understanding the landscape. And preserve your patent rights, provisional applications. Make sure you're filing timely, and avoid picket fencing if that's a possibility in your world. Yeah.
These provisional applications, how thorough the prior art has to be?
I'm sorry, the what?
The prior art, the research for prior art.
The prior art. How?
For provisional patent applications, how thorough does it
Oh,
be?
you don't have to. Remember, you don't have to do any search. Provisional is just a description of here's what I'm thinking of doing. Now, when you file the actual application a year later, now you have to disclose. I'm sorry, I should have made that clear. So it's very simple. Hey, we had an idea. You could put a handle on the left side of the door instead of the right side of the door, and it can go up and down. Let's file it. Well, most lawyers would say you should just go right for the utility patent. And there's a reason to do that, but it's a monetary decision. You have plenty of things you're going to have to spend money on. Provisional patents allow you to preserve some rights and do something later. You may, as you start to develop, find other things in the course of the year of development that would say, the utility patent I would have done on that first application wouldn't really be the one I'd file. So it gives you time at very low cost. And at the end of the day, you can abandon and possibly even file again on a slightly different invention. But like anything, you've got limited resources. Where are you going to spend it? If it's really important, maybe it's the patent. If it's getting a prototype to work so you can show it to a potential big partner, you have to make those decisions. Okay, speaking of lawyers, you're buying by the hour. Be a little disciplined about it. Understand your goals. Plan ahead. Don't. All right, so I file a provisional. It's 363 days from the provisional filing, and I realize I gotta get a utility patent on. I call the lawyer up and say, I gotta get the patent filed. Well, it's gonna cost you a little bit. They're gonna drop everything. So plan ahead. Provide the background information. If you haven't, go read if you're thinking about it, go read a patent in a field that's similar to yours, and see if you could write up an idea you have along that. Forget the claims for the time being. Have a clear agreement on budget. There are firms that will do sort of fixed fee things. You're in an ecosystem where law firms recognize that the next big thing could be the person coming in the door, and they're willing to cut some deals, especially if you've got some pedigree around. We're a team from MIT or an MIT Harvard team, or something that suggests these people might really have something. They'll play with you for a while, and so just take advantage of that. If I've given you some background on IP, so you know something about it. There you go. And read my 10 Commandments of how to work effectively with lawyers. It's on the website. So, okay. Now, because we're at MIT and there are lots of ideas floating around, it's important to talk a little bit about university licensing. In typical sponsored research where somebody pays MIT to do work, the sponsor doesn't own it. MIT will own it. The Bayh-Dole Act was a big thing back in 1980. Federal government spent a lot of money on research, and federal government owned all of the intellectual property. But only about 5% of the things out there were ever turned into patents and commercially licensed. So Bayh-Dole came along and said, you know what? Why don't we give the universities the ownership rights for the work that's done there? Because they know better than we do. And that dramatically accelerated it requires universities to retain ownership, and they have to file patent applications or inventions arising from funding. They have to give licensing preference to small businesses. That was a very key part that enabled a lot of the startup kind of stuff you're going on. The government does get a royalty-free license to come in and use it. So depending on which you're in, that may or not be an issue. Normally isn't. And universities have to provide some program to do all of this. In MIT, it's called the Technology Licensing Office. And they share royalties with inventors. I won't go into the royalty splits with the university, but so the TLO is what happens here. Now, the TLO, some university, it seems like what their licensing office's prime mission is to maximize revenue, right? So this is like I got a golden goose here. I'm going to squeeze it and get everything I can out of it. And of course, you end up killing the goose. But I've dealt with many licensing officers around the country. MIT is by far the most sensible one I've encountered. Their primary goal is to make sure, like we talked about last night, the MIT seal, hand in minds, get stuff out there that helps the world. Now, we want to make some money, but that's a secondary goal, and you can read about stuff here. MIT will own the patent if it's under sponsored research or significant use is made of MIT facilities. They never assign ownership, they just license. And sponsors do get a first right, which did create a problem at the Media Lab when it first set up, because the Media Lab had all these sponsors, all these big companies. And if every company that sponsored the Media Lab could have rights in whatever happened at the Media Lab, how would anything ever get commercialized? I had an MIT professor once as a client whose postdoc split his time between the Media Lab and CSAIL, the computer science. And the Media Lab people were saying, wait a second, we own not only what the postdoc was doing, but the work that the professor did. So we had to go in and have a little discussion about how that wasn't going to work and come up with a different way of dealing with it. MIT can waive the invention if these kind of things are there. It's possible to go in and ask for a waiver, which could be important if you're going to be licensing something. Because look, what happens around MIT, there's sponsored research, but there's a lot of just smart stuff going on. So there are ideas all over the place. And making it clear, who did this and who has rights in it. But they will do that. By the way, the last part, no plans to use MIT facilities to reduce to practice. That's basically why Kendall Square is there. So the work is done in professor's lab. I'll walk across the street, Lab Central. That's where we do all of the other stuff. We come back, we do our teaching and our research. We go back across the street and we continue it and make sure that doesn't get messed up. Also, there is a provision for non-MIT invented stuff. If people can come and say, hey, I have a great idea, would you take it at the patent office, at the technology licensing office? I'm not sure exactly how often that actually happens. Now for startups, you don't have any money yet. You're trying to figure out, you got your model, you took this course, you got a team going, you're thinking about it, you realize maybe there's some rights you need out of MIT. Gee, do I have to go negotiate a whole license? Well, you can get an option to obtain a license. These are generally 6 months to a year. Everything's negotiable here, but you have to assume ongoing patent costs at some point. Maybe not when you have the option, maybe when you get the actual license. There might be a modest upfront fee, again, negotiable. Could be exclusive or non-exclusive, depends on the technology. You might need a non-exclusive license for something to do the thing you want to do exclusively, that's yours. It gives you a right to take a license, allows you to go out and evaluate the market, and now you can go to financing sources and say, look, here's the deal. I got an option to get this stuff from MIT, and I got this team, and here's our beta alpha prototype, and here's my concept, and we're looking to raise X number of dollars, so now you have a story that's sort of complete. And then you could have to go back and actually get the license, but you have a right to get a license. Typical license terms. These slides will all be posted. There are a number of components in a license. There's the issue fee. You got to pay me to give you the license. There's usually a license maintenance fee saying you can't, I got to see something to keep the license in effect. You have to actually do something. I don't want you sitting on the shelf with this. There's a royalty. There are patent costs because what the TLO does is go out and hire lawyers to prosecute patents. And if this is a typical kind of thing, if you're not giving any equity to the university, those are sort of a range of terms. Again, everything's negotiable, but sort of that sort of thing. With equity, it changes a little bit. The royalty may drop a little bit. The issue fee may be lower because you're, it might be lower because part of what you're giving is some equity in the company along with the cash. And typical equity terms would be single digits that don't get diluted. By diluted, it means I'm going to own 5% through the first round of your financing. So whatever happens at the end of that financing, I still own 5%, let's say. I get future rights to participate if I want. These are sort of typical royalties for university patents. Again, all over the place. It's a range. You can see some of them depends on whether this is a small thing or a big thing. Is it a pharmaceutical? What stage is it, a clinical or preclinical? The thing to remember is think about as sub-licensing. You may take a license, and part of your business deal is you're going to take the license, develop a product, and you're going to sub-license somebody to go and manufacture it and everything. Well, you're going to get paid something. You may have to pay. Be careful about how sub-licensing works, and also royalty stacking if you end up having to get 5 different licenses. Before you know it, if everyone gets 10% and you have five of them, all of a sudden you've got 50% of your company given away. That's not going to work. So you have to think about all those things. I told you I wasn't going to get very far. Timeline. Let me do a quick thing on legal form for your venture. If you do nothing, and a bunch of you are getting together, you will be a general partner if one or more persons are engaged in business for profit. You don't need a written agreement. You will be a general partnership. What that means is there's joint and several liability. So if you and I are partners and you do something that creates a big liability, they can go after you or they can go after me. Not very comforting, right? Ownership is based on the dollars invested. So if I'm the idea person and you're the finance person, you put in $1 million, I'm putting in my idea. Without changing anything, you end up owning all the profits and everything. And outside investors don't want that unlimited liability. So in general, you don't want to fall into that trap. Most cases, when you go through, I could do a whole session on picking entities, but in most cases, if you need a lot of outside financing, typically you'll go to a corporation, often Delaware. Delaware that has a long history of corporate law. There's more settled than other places. And the reason to incorporate sooner rather than later is to avoid any personal liability. Avoid liability from your partner. And minimize Section 8 personal tax, 83, which I'll show you in a moment. Once you do, you have to make sure you actually abide by being a corporation. So you treat it as a real entity. You don't commingle funds. You sign in the corporate names. You keep minutes. Now, a corporation is a person. I don't know if you remember Romney saying, a corporation is a person. That went over really well with the average voter, But legally, a corporation is a person. It has rights, etc. And that means it can be taxed. And if you don't do anything under the federal law, it's a C Corp, subchapter C. You can make an election if you qualify to be a subchapter S, which means there's no corporate level tax. The tax gets passed through to the shareholders. You have to have fewer than 100 shareholders, one class of stock, and there's some shareholders you can't have, like foreign nationals, corporations, or venture firms. So, hey, but most startups have losses. I raise money, I developed a product, I'm losing money until I finally get the product ready, and then we hopefully make money, and then we're off to the races. So who cares? I'm not going to get taxed as a corporation while I'm losing money. Well, the real issue is on the exit, if you end up selling the company and you're still an S Corp. Because if you're a C Corp, you'd have a corporate tax, and then the money distributed to the shareholders would be taxed, and you'd get, in this case, about a 50% tax. If you're a subchapter S, you don't have a corporate level tax, so you're going to save maybe 13%, even more, depending. This is the highest tax rates, and I didn't include all the Medicare additional tax on top of it. So that's generally my advice: is incorporate if you can, be an S Corp, because you can always. You will flip to a C Corp once venture capital comes in, if that's your choice, because they're not a qualified investor. Oh, good. Section 83. We're going to finish with this. This is important. How many of you have ever worked for a company and got a paycheck? And it says you made $1,000, and then what does it say? Government, and then you have your net, right? So you get, I don't know, let's say you get $700, whatever the number is. Okay? You got the cash, you had to give some of it to the government. You grumble, but hey, I got $700. Section 83 means, look, you can be taxed even if you don't get cash. So if you receive property in connection with providing services, you have ordinary income, which could be taxed up to 40% at the highest rates. It's equal to the fair market value of the property you got minus what you paid for it. So if I give you $1 million for 50% of the company, and you have the other 50%, what's your 50% worth? Well, let's say I own half the company, I put $1 million in, so there's only $1 million in cash in there. So maybe your half is worth $500,000? What did you pay for your stock? Because you're the founder, after all. Next to zero. Wait a second. Ordinary income is $500,000. And let's say your tax rate is 40%. You owe $200,000. Just pay up. Oh, but wait a second. Why would I buy half the company for $1 million if the other side wasn't worth $1 million? So maybe you owe $400,000. I'm sure you have that cash sitting around somewhere. Yeah? Are you worried? Yeah. You should be. And it gets even worse, because this rule applies if you have a risk of losing that property, then you don't get taxed until that risk goes away. What does that mean? Well, it's typical when an outside investor comes in. I'm giving you the money, and you're promising you're going to do stuff. If you do the stuff you say, then of course you get the stock. But what if you walk away tomorrow? So we're going to have your stock vest over time, right? So at 1 year it vests, and finally let's say it fully vests all at once in 4 years. Well, at the beginning, your stock was worth probably nothing, right? Because that's what you paid for it. And in a year, now it's going great guns. Now we're measuring what the ordinary income is, and it could be a huge amount of money. There was a case on the West Coast where they finally brought in a CFO after several rounds of venture financing, and he asked around, like, where are all the 83B election forms? I just want to check them out. And the question was, what's 83B? Nobody had ever, the company was valued in $50 million, $100 million, and there were a lot of lawsuits for failure to give that advice. So how do you get over that? You do what's called an 83B election. You have to say, look, I want to measure whatever my tax is now, and I have to file that within 30 days of getting the stock. And if you do that, then that limits your ordinary income. So the way to avoid the 83B trap is to separate in time when you get the stock from when the money comes in. So if you incorporate today and you issue the stock today, and it takes 6 months before, optimistically we get any money in from the outside, you say it was worth nothing, a dime a dozen. Back then, now it's worth a bunch because we brought some money in. Then you file the 83B election. But typically what doesn't happen is the stock doesn't get issued in time because you're too busy, we're not quite sure who gets who. And I showed you this one the other day. If we're trying to divvy up the stock at the beginning and you have a sole technical inventor and the business people, it's a hard discussion. So we procrastinate, and then all of a sudden, I can't tell you the number of times when I was practicing law, somebody would come in, hey, Joe, we got a term sheet. We got to get the company all set up. Okay, so what happens between today and the day we close? Now if we'd incorporated 6 months ago, there's more of an argument. So, and with that, I'm going to call it half the evening. The other things you'll see on the website, we're going into things like founders agreements. And this is all in the things, some discussion of founder equity splits. Again, I basically taped a version of this, knowing I couldn't fit it all in, and different types of stock and everything. So with that, we'll take our mid-evening break.